pages, that was the referral to this office. On the face of it, it would indicate it's a supplemental referral. As you know, there were previous referrals involving both Alyssa Denhoff, Gutierrez, Leo Jennings, and others. Matters happened at the Elections Commission as well on a complaint filed by the Inspector General and the Secretary of State. At least in my understanding and belief, based on the investigation conducted, this would conclude the investigation by all law enforcement related authorities into that 17-month tenure during which Marc Dann was Attorney General, and culminated, as you know, this morning in him entering guilty pleas in municipal court in front of Judge Ted Barrows. I think you were all there. So we're happy to answer any questions that we think we can that you may be remaining.
What's the significance of the Alford plea then? How does that work?
An Alford plea is something that the Supreme Court sanctioned probably 25 or 30 years ago in a capital case. It's where the defendant entered a plea to a non-capital homicide in which he wanted to continue to explain, I guess, the circumstances and reasons why he did that, and explain, I think, his lesser degree in his mind of culpability. And the court said, well, you either have to plead guilty to everything and admit you done wrong, or it's not an acceptable guilty plea. And it was that case, Alford versus North Carolina, or North Carolina versus Alford, that the Supreme Court said no, that someone is entitled to, if they plead guilty, and under Criminal Rule 11 here in Ohio, a guilty plea, even an Alford guilty plea, is what the rule says is a complete admission of guilt. So whether it's a Alford guilty plea or a guilty plea, it's not referred to in reliance on Alford. And nevertheless is a complete admission of guilt of the charges contained in the complaint. So I guess an Alford plea is, it allows a defendant to say, I did this to avoid the consequences of the trial or consequences of more and additional charges. Someone may be offered a plea, for example, to 1 or 2 counts where they could have faced 14, and then they say, well, I'm pleading guilty to 2 counts because I don't want to defend or face the consequences of 14, and the potential penalty frequently may be attached to it, or someone could enter a guilty plea to several charges that might be misdemeanors where there were potential felonies, and so they're doing it to avoid the possibility of a felony charge, and would want to reserve the right to call it an Alford plea.
Could you explain the ban on serving in public office or having public employment? Would that extend to his doing legal work for a municipality, a government of any kind?
I'm not sure I am able to parse exactly what that is. For sure, soliciting or receiving or paying, providing unlawful or supplemental compensation requires a 7-year thou shalt not serve in any public office. And I think the issue, obviously, any elected office is something that's prohibited. How broad beyond elected office, I am not sure that would expand. I am familiar, for example, having been city attorney for the city of Columbus, as most of you know, that's an elected position, and so someone couldn't be an elected city attorney. Some cities, for financial and efficiency reasons, contract with private attorneys, so it might be different if I have a contract to provide legal services than if I'm the public official. But, excuse me, David here has the statute, and so you are disqualified from holding any public office employment, so it is broader, or position of trust in this state. So it would be, broader than elective office, and it may well include the kind of thing you're talking about.
Mr. O'Brien, 2 years, almost to the day now, that this has been under investigation, and just now it's come to a conclusion. What has been the difficulty in bringing it to a conclusion prior to now?
There was an extensive investigation that was done first by the Inspector General, secondly, I think, by the Secretary of State with respect to election matters, and then finally by the Ethics Commission. And I think in that equation, the Ethics Commission because they operate under a confidentiality statute. I think they actually were the first ones to open an investigation with respect to Mr. Dan based on public reports. And so there are a lot of things that were looked into, a lot of matters that were required, and they were very thorough. And I commend Mr. Freel, and he's not here, but he may be in the crowd, a gentleman by the name of Craig Morgan, spent the better part of his full-time employment investigating these matters. That included more than Mr. Dan. Mr. Gutierrez had workers' comp issues that entered into that realm. There were, as I say, elections-related issues. There were issues that caused documents. As we all know, documents, whether it's from a bank or any other entity, you just don't obtain them overnight. So it was an extensive investigation.
The other thing I would say in response to that is that the investigation by the commission brought out that there was transition funds going to Mr. Gutierrez. It was the Ethics Commission Special Investigator Craig who found the $5,000 transaction from the transition account to Mr. Gutierrez, which then required a variety of other subpoenas to sources of payments to that transition account and then expenditures from that transition account. And the prosecutor provided grand jury subpoenas as well as subpoenas that the Ethics Commission issued just following, in effect, the money to see where all the sources of money were. And of course, you know, there were gradual pleas by Mr. Gutierrez, Mr. Jennings, Mr. Simpson, and Alyssa Lenhoff that all added additional information to what you'll find in the report as a result of what happened.
How helpful?
Yeah, and I would say, parenthetically, in that context is, as you well know, probably most of you, because you wrote the stories, there's not much contained in this report, or at least the charges, I should say, that wasn't in the public domain a number of years ago. The problem is you could have something in the public domain, but to make something court-ready and provable to a jury beyond a reasonable doubt, where witnesses come in a courtroom, raise their right hand as necessary, and Mr. Jennings may say something to one of you, and it may be in the public domain, but unless he's a state's witness, and he does not become a state witness until such time as his Fifth Amendment rights may be overcome, and the only way we overcome those kind of things is to either give someone immunity or to charge them with what they're charged with and enter into a plea agreement with them. That it was done in this case, and as you know from covering these kinds of cases, there is a lengthy process whereby people who may be labeled witnesses or targets have to be dealt with in sequence, and this was a perfect example of that occurring in sequence, and certainly until probably the last month or more, certainly 2010 as a calendar year, we would not have available to us Mr. Gutierrez as a witness, Mr. Jennings as a witness, Mr. Simpson as a witness, or Ms. Lenhoff, and there were, some issues that still remain regarding, I think everyone's familiar with the spousal privilege that arises. So, even though she may have a plea agreement to require to be a witness, that didn't overcome a statutory privilege for, spousal communications. So, there was a process that when you need to get to a certain point that you maybe have to follow, and I think that occurred in this case.
Mr. Freel, you, as Mr. O'Brien suggested, your office started this case these months ago. Now that we are done with this, are you satisfied at the outcomes?
I think that anytime you have a former statewide office holder, let alone a former Attorney General of the state of Ohio, enter guilty pleas in front of a court of law to ethics and related violations, you have accountability to the public for his actions. And as I think I heard him say, he accepted full responsibility for those actions in the courtroom, at least before the judge. Really, it's a sad day for the state and the Attorney General's office. There are very, very good, talented employees within that office that have suffered because of the actions of the former Attorney General.